let me know you're ready to have your case called. Otherwise, if you can please remain on mute until such time as your case is called. All right, Ms. Dela Fe Perez, I see you there raising your hand. I'll take your announcement, please.
Hi, good morning, Judge. How are you?
Good, how are you?
Good, good. I'm here on P0061228.
All right, that's number 2 on the court's docket, Amanda Denise Alvarado versus Jose Luis Ramirez Jr.
Yes, Your Honor. In this case, the respondent has not been served, so I would be asking for an extension and another court date so that we can make sure that he does get served by the next court date.
Give me within 14 days, Eddie. So, all right, April 6th.
Okay.
At 9:30.
Okay, great. Thank you, Judge.
If you can just submit an order extending the ex parte TRO, please.
Yes, Your Honor, we will do that.
Perfect.
Thank you so much.
You're welcome.
May I be excused?
Yes, you may. Thank you.
Thank you. Bye-bye.
All right, Ms. Martinez.
Good morning, Your Honor. I'm here for a friendly suit. Plaintiff's counsel is Hector Bustos and Savannah Gonzalez was the ad litem. I'm not sure if they're here today, but we had a quick up if that's possible.
I do see Ms. Gonzalez present. I don't see Mr. Bustos quite yet. We'll try to make contact with Mr. Bustos' office. Hang tight, and we'll circle right back.
Okay, thank you, Your Honor.
All right, thank you. Tania, did I pronounce your first name correct?
Good morning, Your Honor. It's Tania Olet.
Tania, good morning.
Good morning.
What case do you have?
CL 213784I, Discover versus Laura A. Lopez. It's a motion for default judgment. No answer has been filed.
Can you repeat that cause number one more time? I don't see it on my docket.
Sure, and I may have it incorrect, so let me just double check. CL-21-3784.
Yeah, what is the letter that it ends with?
Like igloo.
Oh, we're H, so wrong court.
Okay, they gave me the wrong information. Okay.
I is court 9.
Yes.
Yeah, county court 9. And we'll check real quick.
Let me just see if you have it. Yeah.
Do we have it is set for today, county court 9. Can you contact our office?
Yes, Your Honor.
And we will give you we will try to get you in contact with somebody over there because I don't know if they answer or if they're answering their phones when they're online.
Okay.
Our number is 292-7740.
Thank you, Your Honor.
You're welcome. All right, Linda, good morning.
Good morning, Judge. How are you?
Good.
Good. I haven't seen you in so long, then I see you twice this morning.
Yeah, we see each other dropping off our kids at school, and then we see each other here. Good. What do you have?
Judge, I'm here on a minor prove-up hearing. It's CL-21-2096-H.
Andrea Mijares versus Rene Rodriguez, Jose Garvais, and Francisco Martinez.
Yes, Your Honor.
All right. I have Mr. Reyes present. And who's on the other side? Ms. Julia?
I am for the plaintiff. Frank Sabo sent me a text that he is in County Court 9 for another hearing this morning. He did want to attend, and also my client has not shown up to my office yet. My staff is trying to get a hold of her, so we're not quite ready to proceed.
Okay. Ms. Castillo, can you hang tight? Mr. Reyes, can you all hang tight?
Yes, Judge.
Circle right back. Let me go back to Ms. Martinez because I do now see Mr. Bustos on. Hector, you're there?
Yes, Judge, I'm here.
Are we ready? Savannah,
we're ready to go, Judge.
There's still some confusion with regard to the judgment. There is a judgment.
All right. Savannah, are you ready to proceed? Savannah, can you hear me? She might be on another Zoom call. We will try to contact her office, let her know that we're ready for her. Mr. Bustos, don't go anywhere. Ms. Martinez will be right back with you as soon as we get Ms. Gonzalez, who is the ad litem in this case, up.
Okay, I'm good.
All right.
Thank you, Your Honor.
Move over to Mr. Daniel Cabrera.
Morning, Your Honor.
Good morning.
I'm going to ask for, let me give you the cause number really quick for you, Your Honor. It's CL 21-3089H. Goldman Sachs versus Zahida Gonzalez.
All right, yes, status conference on a motion for default.
We just actually talked to Ms. Gonzalez. There was, in the previous hearing, there was a Rule 11 agreement. There was a little miscommunication about delivery. So I'm just requesting a reset date for the status to make sure this goes through for 45 days.
Let me go ahead and give you May the 11th
Okay.
at 9:30.
Thank you, Your Honor. That's all I have. May I be excused?
You're excused. Thank you so much.
Thank you, sir.
Yeah, Ms. Olson, are you ready to proceed on some of your cases?
Morning, Judge. I'm here on 5 status hearings. I do see that the defendant is here for CL 19-3492H.
Did you say 3492?
Yes, Judge.
Okay, Portfolio Recovery Associates versus Crystal Arjona. And I have a note here that the parties had reached an agreement and an agreed order was to be filed.
Yes, Judge. Unfortunately, we have not been able to reach the agreement. The plaintiff is ready to proceed on the motion for summary judgment. So we would just need a date for that hearing.
Ms. Arjona, good morning.
Good morning. Hi, sir. Actually, last court date, I did reach out to Miss Olson with an email and I asked her for some things that I wanted, like, because I've gone through through fraud and all those things. So I asked her like if she could send me all those documents. So I've been asking for them for like months. They just sent them last month. And that's why I made the extent on the court. I did talk to Ross and Starn and I asked if I could do like a settlement or a payment plan. And they said that I had to reach out to Portfolio. So I reached out to Portfolio and they told me that I had to reach out to them. So they had me back and forth. They both keep saying that they don't own the account and they keep redirecting me. So
I can address that. We would be the ones that settle. I think this is our 6th or 7th setting. The issue was that she had a formal dispute with the original creditor. So during the time of the dispute, we were not able to negotiate. However, the dispute has been cleared. They did investigate. They did not find fraud. So we have been cleared to negotiate. She has been in touch with our firm. We were not able to accept her offer. I have been in touch. She has my information. She can deal with me directly, but we have not been able to settle it. She has been served with the motion for summary judgment that does have the attached documents. We have mailed them from our office. Again, this is our 7th setting and it remains unresolved. We are ready to proceed. We have been ready to proceed.
Yes, but like I've mentioned, like I called several times and you guys do record. So you probably have where I've been calling constantly to both companies and both of the companies say that you don't own the account.
We do not. We are the law firm. Portfolio Recovery Associates is the owner of the account.
But when I call Portfolio, they say that I have to get with you guys and then you guys.
They're attorneys, correct. They won't exactly. So I apologize. I think the volume cut out. They direct you to us because we are their law firm handling the account. They are the owners of the account, but they don't negotiate directly when there is a pending lawsuit. They direct you to the law firm. I do see that you've called. I've seen your call recordings. I have spoken to you multiple times.
And the last time that I did send you an email, I was trying to see if you could work with me, and the only thing you replied was that you are not going to work and that you would call the court.
When you sent an official dispute, we were not able to negotiate because there was a pending dispute. However, that has cleared.
The only reason you guys send me all those informations and all those documents was because I made the claim where I with like the burials that you guys were not replying. That's the only reason you guys send me the documents.
Judge, we did send the original, the motion for summary judgment has been on file since 2021. It's on the court website. I have directed her to the website. We did serve a copy of the motion and the business records in 2021. We did resend them from our office. I can see when it was sent, when she requested the documents, she says that she didn't receive them. I said she can always view them on the court website as well. But we did resend them.
Yeah,
We've appeared for several hearings. At the hearings, we reach a verbal agreement, and then after the hearing, it just does not, we're not able to proceed with it. I'm not, if there is a formal dispute on a credit on an account, we do pause to allow time to send the documents. We can't negotiate during that time, and we've been through this several times. We did send documents again in December after the last hearing. Let's see here. I do see that it was mailed on or about December 16th, 2021. Again, after serving with the original motion and business records.
Okay, and so I guess the issue here is the fact that Ms. Arjona, and I'm just going to take a wild stab at it, Ms. Arjona is wanting to negotiate, but at an amount that's lower than what Portfolio is willing to accept. She's wanting to do maybe $25 a month, and Portfolio is saying, listen, it's got to be $200 a month, and then everybody kind of drags their heels and digs their heels in the ground, and that's kind of where we're at. I'm just taking a wild stab at it here.
Somewhat. It's a little bit more complicated than that. We did reach a verbal agreement last time, and when we left the hearing, I did get an email. Defendant said she was not comfortable proceeding, that it's so, and then she launched a formal dispute. So we had a pause on the negotiation because she did contact our client saying that she did feel harassed, and whenever those claims come up, of course we do have to pause. My client does investigate, and so we're not able to negotiate during the time of those investigations. This has been going on for over a year.
Yeah, I even called if I was like, I could get a loan for $800, $900. I could, if you guys would accept. And that's when you had me back and forth that neither of you two companies had ownership of that account. That's why I never gave a payment.
That's, my client is the owner, we're the law firm. We do process all of the payments in the negotiation. But yes, we have not been able to, we have reached verbal agreements multiple times. However,
can we memorialize that that verbal agreement somehow so that we can basically try to take care of that today?
We did last time agree to $50 a month. However, it's my understanding, Ms. Arjona, that that's not how you want to proceed. Is that correct? That was what we agreed on the last at the last hearing.
I mean, $50 seems reasonable to me.
Yeah, that's right.
Okay, so how can you send her some documents that she can execute and sign, and I can reset this for Monday just to make sure that those documents were done, executed or signed by Ms. Arjona, and we can put this behind us already. I don't want to give it a long reset. I want to give it a short reset.
Yes, Judge, if we could proceed on the motion on Monday, if paperwork has not been finalized, we would like to put this to rest.
All right, let me go ahead. Ms. Arjona, I think a $50, whatever that agreement was, $50 a month is more than reasonable. And I'm going to go ahead and reset this to case till Monday. Eddie, give me Monday's date. No, Monday's not the 10th. The 28th. 3/28 at 9:30. Let's get those that paperwork signed. Let's get it sent over, Ms. Olson, and let's get it signed, Ms. Arjona, and we'll get this already taken care of. Otherwise, we'll see each other. We'll still see each other on Monday, but Monday, I hope, is just an announcement that it's been taken care of.
Yes, Judge. Thank you.
Yeah, do you have anything else, Ms. Olson?
I do, Judge. Also on CL 18-3446-H.
Portfolio Recovery Associates versus Abel Garcia.
Yes, Judge, that one has been settled and we did file an agreed judgment this morning.
Perfect. Judgment filed. All right. Anything else?
I do have 3 others, Judge, that we need to set for trial.
All right.
I have-
Is that CL 18-58-53H, Portfolio Recovery Associates versus Vanessa Ramos?
Yes, Judge.
Is Vanessa Ramos present? Vanessa Ramos, if you're on mute, please unmute yourself. Vanessa Ramos. Give me a bench trial date, Eddie.
Yes, Judge, it's due April 20th.
All right, April 20th at 9:30.
Thank you, Judge.
All right, I don't see another portfolio case. Do you have maybe under a different type of style?
I do. I have one more portfolio and one with Crown Asset Management. The other portfolio is CL 21332.
Okay, yes, Mr. Jose Cantu is present here in person.
Okay.
Mr. Cantu, can you step to the back so that we can have you on our camera that we have here in person? Give me 1 second, Ms. Olson, we'll have him walk over to the back. We have it, our computer set up in the jury room, so there's no interference with our audio. All right, Mr. Jose Cantu, good morning.
Buenos días.
Buenos días.
Good morning.
All right, and this is also scheduled for the same thing, and you're asking for a trial date on this one, Ms. Olson?
Yes, Judge.
Okay.
Has there been any communication between portfolio, yourself, Ms. Olson, or Mr. Cantu?
No, Judge, we have attempted to call, but we have not been able to reach Mr. Cantu.
Okay.
Mr. Cantu, what's the best way of communicating with you if someone from the law firm of Ms. Olson can reach you to see if something can get resolved?
Es la mejor manera de comunicarse con usted para que la oficina de la señora Olson se comunique con usted.
Ponerme este número y está hablando.
No, que es la mejor manera de comunicarse con usted. ¿Teléfono o correo electrónico?
Pues sí, por
Voz alta.
correo electrónico.
By email.
Right, and what is your email?
Es su correo electrónico.
Cantú.
Alfredo Cantu. Oh,
Alfredo.cantú.
Alfredo.cantu.
2243
2243
arroba gmail.com.
gmail.com.
And Mr. Cantu, do you read English?
¿Lee usted inglés? No.
Okay. We will have a representative reach out to him.
All right, perfect. I'm going to set this up for a bench trial on April the 20th, also at 9:30. April 20th, 9:30.
Vamos a regresar el 20 de abril a las 9 de la mañana para tener un juicio ante el juez. Y uno de los representantes de él se va a comunicar con usted. Antes de eso.
All right, that is it. Mr. Cantu, you're excused.
Todo, señor.
The next one you have, Ms. Olson, is CL 201041H, Crown Asset Management LLC, Assinee of Santander Consumer USA Inc. versus Elma Zamora.
Yes, Judge.
Is Elma Zamora present? Elma Zamora, if you're on mute, please unmute yourself. Elma Zamora. Link was sent to Ms. Zamora's email. I will give you the same date for a bench trial of April 20th at 9:30.
Thank you, Judge.
All right,
And those are the only matters I have before the court this morning. May I be excused?
you're excused. Thank you.
Thank you.
All right, let me go back to some of our, we now have Mr. Sabo present. So I have Ms. Julia, Mr. Sabo, and Ms. Cavazos, I hope. There we go. All right, let's go ahead and recall this. Mr. Reyes is present as well. CL 21-2096H, Andrea Mijares versus Rene Javier Rodriguez, Jose Garfais, and Francisco Martinez. Friendly suit. Are we ready to proceed?
Kathy Julia for the plaintiff. We are not ready to proceed. Just to give you a little bit of background, Judge, this is a case where my client, Andrea Mijares, is the mother of the injured child, Alejandro Marroquin, who was 13 years old. Her boyfriend, Francisco Javier Martinez, represented by Mr. Sabo, was the owner of a vehicle and entrusted it to the 13-year-old, who then gave it to his 16-year-old friend, none of them having driver's licenses. And while out on the road, they were involved in an accident with Mr. Rene Javier Rodriguez, who is represented by, I think, Ms. Castillo. So we ended up, obviously suing the other driver who caused the accident and the owner of the vehicle for the negligent entrustment. There was, not any serious injuries involved in this case. There was quite a delay to treatment, and, everything was resolved, but we have had difficulty with this client. I think you can tell from the facts that not exactly I have to say, not exactly the most responsible adults in this house. And while we have received, assurances that she would be here today, and in fact, we set her up to go to my office to make sure that she would be here. And I'm assuming that the ad litem has had an opportunity to meet with her, or at least speak with her on the phone. She has not shown up, and despite multiple texts from myself, my staff, she is nowhere to be seen.
Mr. Reyes, have you had any communication?
Your Honor, I did have a meeting with the mother. She did come to my office, Ms. Mijares, and we had a Zoom conference with the minor, Mr. Marroquin, and we did review the disbursements and the paperwork in the case, medical bills and records, and I do find that the proposed settlement is in the best interest of the minor, but I don't know why she's not here today. I haven't had any contact with her since I had the in-person meeting with her in my office about 2 or 3 weeks ago.
Okay. So I guess at this point, Mr. Sabo, Ms. Castillo, I guess we're in a holding pattern until Ms. Julia can get her.
Judge, I don't have any problem with the court approving the settlement based on representations of Mr. Reyes. My client wasn't at fault in the accident, and the injuries are minor enough that I'm not too concerned about this case coming back at us later. So, I don't even really think we need court approval for this one in order to protect ourselves. I think we're fine. So I have no issue however you want to do it.
All right, Ms. Castillo, do you hold the same opinion that we can just prove it up without the plaintiff?
Your Honor, I had previously sent the release in full to Ms. Julia. I wonder if her client executed that at this point in time.
Let me text, because the thing is, one of the things that my client has said is that she has transportation problems. And so I don't know. Let me text them real quick. She was supposed to execute it this morning when she came in. What my suggestion would be, and again, this is a great settlement for this kid. We're putting over $4,000 in the registry of the court on a whiplash injury where he delayed. There was a delay to treatment by nearly a month. So, I would assume that all counsel and the ad litem are in agreement that it's in the best interest of the child. If I can get her to sign the release, even if I have to have my staff go to her house and we have it notarized and submit that, would that be sufficient?
That's sufficient for me. I don't have a problem with it. I guess at that point, based on Mr. Reyes's representations, as long as Mr. Sabo and Ms. Castillo are satisfied with the signature, that that you will execute on that document, I have no problem. You can submit it to the court will sign off on it. So that'll prevent us from having to have her log on and delay this even further. So at this point, we'll be waiting on your firm to get us those documents.
Okay, and I will say, she has come in once because Mr. Sabo had sent his release earlier, and she did come and she did execute that release, and it was returned to Mr. Sabo. So I have every confidence that we will be able to track her down and get her to sign the one that was submitted by Ms. Castillo. So if Mr. Reyes is in agreement that this is in the best interest of the child, let's get that submitted, and then we can all sign the final judgment and then get these monies deposited in the registry.
I have no problem with that.
And Judge, as I stated, in speaking with the minor and his mother and reviewing all of the medical records, police report, and the proposed disbursement, I do believe it is in the best interest of the child for the court to approve the proposed settlement.
All right, the court will go ahead and approve that settlement once it's submitted to the court for the court signature with all parties signing off on it. The question that I have is, have your fees been taken care of, Mr. Reyes?
My fees have been taken care of, Judge.
Perfect. Included in the final judgment, submitted to the court. We'll take care of it that way. So basically, administratively, we'll take care of this friendly suit.
On that issue, Judge, of the fees, I just want to clarify whether they were paid already.
Yes, I did send an invoice in the amount of $1,500, and I received a check for $1,500, and it's been deposited.
Okay, then I won't worry about it. Thank you.
All right. Thank you, guys.
Thank you, Judge.
Anything else?
No, that is all. May I be
Nothing
dismissed?
further, Judge.
All right.
Thanks.
Thank you, Your Honor.
Everyone's excused. Thank you so much.
Thank you.
Thank you, Judge.
Thank you, guys. Okay, do we have Ms. Gonzalez did log on. Ms. Gonzalez, are you available? I'd like to take care of this other friendly suit.
Yes, Judge. I'm sorry. Let me just mute my other one.
Okay, let me see. And where's Mr. Bustos now? Did I lose him? I may have lost him. All right, hang tight, Savannah. I'm sorry.
No worries, Judge. Thank you.
Okay, Mr. Martinez.
Morning, Judge.
Morning.
Judge, we're here with Felipe Garcia on CL 192813H for status.
All right.
And I had also filed a motion for new trial, and I think it's set for today on behalf of defendant Otilia Martinez. But she's an elderly lady, Judge, and I'm having trouble getting her on Zoom. And I'd like to ask for a reset within 30 days if the court and Mr. Garcia are not opposed on the motion for new trial.
Mr. Garcia?
Judge, normally I would, it's totally understandable, but this is a suit on a sworn account. And I've attached the deposition excerpts of her son, and I forget his name. His last name is Martinez. Anyway, he was her agent. And they took these cars, they sold these cars, they turned them into parts, and then they sold them as scrap metal. My client had a contract with them. It's attached. He's got all the credits. He's got all the accounting, all the numbers. So I mean, there really is no case here. One of the things on a motion for new trial on the default judgment, there being 3 according to Craddock versus Texas Sunshine Bus Lines. The one they have a problem with is they have to have a meritorious defense, and I don't see where they have a meritorious defense. They could testify that she could testify that she didn't know about it, didn't see it, and it was negligence, mere negligence, and that maybe we won't be unduly prejudiced, although I submit we would be. But the meritorious defense is the big problem for them. They have no meritorious defense. And quite frankly, when I first filed this lawsuit, I reached out to Mr. Martinez and I said, Joe, let's take care of this thing, man. I mean, they own the money. I'll get a discount from this guy. Let's get it settled. Joe said, okay, call me. I called Joe at least 4 times, maybe 5. And I had not seen him or heard from him. And this is over 2 years ago until the last hearing we had a month ago. You know, Joe, you're laughing and smiling, but you never caught it.
Judge, I represented Saul Martinez in this case, and he died in September, and I didn't even know about it until we had a default judgment hearing. And then the Otilia Martinez is Saul's mother, and I did not represent her. And then when she found out about the judgment, they came to my office and we researched the citation, which was by certified mail. And the signature on the certified mail receipt is not Otilia Martinez's signature, Judge. It's her daughter's signature. So Otilia Martinez was not served with process in this case. And I would just like to have an opportunity to have her daughter and the old lady, Otilia, testify. And then we'll get, I'll be able to, I just got in the case about 3 weeks ago, Judge, for Otilia. And then we'll be able to see if there's a meritorious defense or not. If not, well, they got to pay Mr. Garcia's client. I'm just asking for a little time, Judge.
Is look at the pleadings and look at the attachments, and he can tell right away that there is no meritorious defense. He's been familiar with this case from day one because Saul Martinez was her agent, and that's graphically set out in that deposition that I've attached. I've attached the entire deposition. I've attached excerpts and highlighted them for the court's convenience. There is no other way. I mean, if need be, no problem. So she didn't get served. I think she got served within the rules. It was delivered to an adult apparently at her household, but that's fine. But their problem is they have no meritorious defense. It's a suit on sworn account. It's plain as day that she owes it. It's plain as day that they always owed it. I try to work it out with Joe, and he cannot feign that he didn't know anything about it when in fact Saul Martinez was her agent. He was the one running the business for her. So there's nothing new here for Joe.
Judge, she's an old lady, and I'd like to have her before the court.
I'm an old man, so.
All right, I think we're all getting older by the second as we hear this case. So let me do this. Let me go ahead and give Mr. Martinez the opportunity, the time to bring his client. And you know, at that point, whether or not there's a defense to the underlying offense, I think at this point, Mr. Martinez is just asking for a new trial so that he can negotiate at arm's length. And at that point, he may not have a defense, and we may be back to, you know, I guess taking another default, because if I grant a new trial, well, then I'd have to grant another default.
Thank you, Judge. Would April 10th be okay?
How about the 11th of April?
That's fine, Judge.
May I check your honor real quickly just to make sure that I'm not going to be in Paris or somewhere? Just kidding.
Judge, I have 2 hearings on that day that are contested. How can we do the 12th?
How about the 13th? I have civil on Mondays and Wednesdays, criminal on Tuesdays and Thursdays.
I'm okay the 13th if Mr. Garcia is.
April the 13th?
Yes, sir.
That'll work, your honor.
All right, April 13th.
Thank you, Judge. Thank you, Sonny.
Thank you, sir. May I be excused, your honor?
Yes, both of y'all are excused. We'll see you April 13th at 9:30.
Thank you, Judge.
Thank you. Oh, Mr. Bustos is back. Okay, so now we've got Mr. Bustos. Now we need Miss Savannah.
Judge, was that Felipe Garcia? I haven't seen him in a while, man.
He's making an appearance. All right, so we've got Hector, we have Ms. Martinez, and we've got Savannah. I think we got all the parties present, I hope.
We're ready.
All right.
I believe so. Ms. Gonzalez, I think we're all ready to go.
Yes, I think so.
All right. Mr. Bustos, who is your client?
Mrs. Rodriguez, Judge, I believe she was on the screen earlier.
Christy Rodriguez or Oralia?
Oralia C. Rodriguez, Judge.
Is Oralia Rodriguez present?
Judge, if you can give me about 5 minutes, Judge, let me call my office, Judge, and make sure they verify that.
So close. We're almost there.
I apologize, Judge. Jesus.
Okay, no problem. Let me skip over real quick. I see Elma Zamora, who is present. This was a case that was called by Jessica Olson. Ms. Zamora, can you hear me? You're on mute. You're on mute. I cannot hear you. Can you unmute yourself? I think if you just tap on your computer screen, or if you tap on your phone, the little icon for the microphone might come up. If you can hit that microphone, that might unmute yourself. There you go. Thank you.
Okay, thank you.
No, I can hear you. Thank you so much, Ms. Zamora. Your case was called earlier this morning. Have you had any communication with Ms. Olson or anyone from her law firm?
I talked to Mr. Let me see if I can pronounce his name. Mr. Ken Kaskin.
Okay.
I've been talking to him since. Excuse me. Yes.
Were you all able to reach an agreement? Because let me tell you why. Ms. Olson is asking for a bench trial. I gave her a date of April the 20th. If it can get resolved, that's the preferred option. That way, it's an agreement. It's an agreement between you and the firm. If not, then evidence will be presented to me and I'll make a decision. But at any rate, the point being is that today, since she is no longer here, I can't take any more action, but I am going to reset this case for April the 20th. And that'll give you an opportunity to continue negotiating with that gentleman or with Ms. Olson directly to see if something can get worked out, okay?
Okay, because I told him that I was working a little, well, right now I started working 16 hours a week. I know it's not much, but he never gave me like a straight answer or something where I know I'm not making a lot of money, but I could give something, than nothing.
And I would only ask that on the 20th, you be ready to present evidence about your wages, how much money you make a pay period, who you work for, things of that sort. Then maybe I can try to see if I can facilitate some negotiation. Okay.
Okay, and I'm trying to also get because I'm a provider so I'm trying to get another client, see if I can get more hours and try to work something out. But I'll keep talking to Mr. Kaskin, and if anything changes, I'll let him know and see if we can get an agreement, and I'll start paying,
Perfect.
what I have to pay.
That sounds great. We'll see you.
Okay.
Don't forget the date, April 20th, 9:30. Do we have our Zoom information?
Yes, I send you a link.
We do have your Zoom information, so we will send you a link on or before the 20th of April, okay?
Okay, it's April 20th at 9:30.
Yes, sir. Yes, ma'am.
Okay.
All right.
Okay, thank you. Yes, sir. Thank
All right.
you.
Bye-bye.
Bye-bye. Bye.
So you've been there?
Mr. Zuniga, sorry.
Morning, Judge. I just
Good
have a
morning.
quick announcement.
All right, what do you have?
On
A TRO, CL 220673H, Stearns Bank versus Nen Ryder LLC.
That's correct, Your Honor. We reached an agreement to extend the TRO. We're close to settling this, I think. So hopefully we can have this settled before we have to have a hearing.
All right, and so I guess at this point, what is your request?
We've submitted an agreed order. We asked that the court sign it.
Oh, okay, agreed order was submitted. Perfect. We will go ahead and sign off on that.
Thank you, Judge. I have nothing else before the court.
Thank you, Mr. Zuniga.
Thank you, Judge.
Make sure we pull that up so we can get that signature on that. Okay, Mr. Redmond, what do you have?
Good morning, Judge. I saw you were running out of participants, so I thought I'd raise my hand. I'm here for a status conference in CL 193904-H. This is Bank of America versus Michelle De La Rima. And I see someone with the name Michelle. I'm not sure if that's her.
Yes. I do see that. She's always present.
Yes. And so, Judge, I will say she filed a report with the court that was from Commonwealth of Kentucky. That report in of itself does not dispose of the in our opinion, does not dispose of the allegations in our petition. This is a suit on a debt stemming from an unpaid credit card account. She filed with the court two things. One was an offer on a plea of guilty by a third party in Kentucky. And the second thing was a pretrial diversion order. Many things. One, there's no mention in either of those documents anything about a Bank of America credit card account. That document, again, I'm no expert in certainly criminal law in Kentucky, but the charge that was brought was theft by deception, not a statute of theft of identity. Two different statutes in Kentucky. The person pled to a lesser charge of theft by deception under $10,000. In our case, it's a credit card account in the amount of $13,000 plus. The account was opened before the time frame in this particular charge, as well as at summary judgment or at trial. My client will present evidence that shows that the money that was a direct deposit from the credit card was deposited into the consumer's bank account, her account. And then there were also payments made from her account to the credit card. And there was a payment made on the account that was subsequent to the facts of the criminal case. So it's going to be our position that, and lastly, with respect to the offer of the plea of guilty, that defendant has agreed to restitution to Ms. De La Rima. So whatever money that they acquired or received from Ms. De La Rima for whatever purpose, they've been ordered to pay that back to her. Doesn't mention anything about a Bank of America credit card account. It would be as if you or I opened up a credit card account. Well, this one was already open. It was already an open credit card account. But if we were to deposit money into our bank account, and then you go to a third party to do whatever business that you want to do with a third party, but maybe that third party deceives you. That in and of itself doesn't extinguish the obligation between the credit card issuer and the account holder. So again, just in summary, Judge, I think the documents on its face that she filed does not dispose of the actual allegations of our case. It just simply on its face says that some person has been charged with theft by deception, have entered a plea of guilty on an amended charge under $10,000 and has entered into a pretrial diversion program, which includes restitution to the defendant. That's what that document says. What we would say is this account has been open longer than the period of time in question in that account, and that the money went from that credit card to the person's deposit account, the defendant in this case, and then there were payments made towards that account. Therefore, there's a balance due on that account. And that's going to be our position. There's two other things. One, a fraud denial letter was issued from Bank of America to the defendant. It doesn't come from our office. It comes directly from the client. That was done. And then two. And let
me interrupt real quick. That's just Bank of America saying we've looked into the fraud and we find that there was no fraud committed.
Correct. And what
this credit card.
Correct. And what they will say is we show that the funds were deposited into an account associated with the defendant, and as well as there's payments from that account to the credit card. Therefore, that's not fraud or identity theft. And again, this person in Kentucky wasn't charged with identity theft. They were charged with another crime. And then the last thing I was going to say is, we obviously, with all these cases, we're interested in trying to resolve this case. Ms. De La Rima, at the hearing that I appeared at, said that she was working, she had a power of attorney, and that she would prefer that we continue to communicate with that power of attorney. That man, who goes by the name of Raymond Weather, he's with a credit advisory firm. He tries to call our office and he wants to offer a settlement, but he won't verify the details of the account. We're in a debt collection business. We have to ensure that anyone that we communicate with has the defendant or consumer's name, address, social, or date of birth, any 2 or 3 of those factors, but he refuses to provide that information to us. So therefore, we can't talk to him as far as, just like Ms. Olson was saying earlier today, there's certain things that we have to do because it's a very complicated, there's lots of
Yes,
federal statutes involved. So
yeah.
we would be happy to talk to either Mr. Weather or
Yes,
Ms. De La Rima, as long as we know who the person that's authorized
yes,
to speak
sir.
on the account.
Sir, I have answers to that, and Judge, can I talk, please?
Go ahead.
Judge, so first, I have to verify with the attorney in Kentucky about that mentioning the name Bank of America in the plea guilty documents, but they are all aware and have all the documents about, I mean, what have transpired, and also my counselor, Mr. Raymond Weathers, already have my private personal information, such as social birth date, for him to be able to provide to the Bank of America when he communicates with them again.
Okay, perfect. I think that takes care of at least that one issue. Maybe Mr. Weathers didn't have the information when he spoke with you, Mr. Redmond, or a representative from your firm. I would ask that Mr. Redmond, you reinitiate that communication with Mr. Weathers. Based on the assurances that Ms. De La Rima has given us here today, he has that information now. Maybe he didn't have it at the time, and I'd love for that communication to continue. Ms. De La Rima, I'm also going to ask, I'm going to reset this for 2 weeks. And in the next 2 weeks, I'm going to ask that you can, if you feel that this was still a fraud that was committed on that Bank of America card, you're going to have to speak with the prosecutors. You are the victim. You have rights, and you have rights to communicate with that state prosecutor to give you information about the debt or the debt that was, I guess, the nature of the offense for which he pled guilty and is on pretrial diversion. Because I can understand Mr. Redmond's position. I see it. And if there's no agreement and we go forward for a bench trial, then those are some of the obstacles you're going to have to overcome, which is the arguments that he's already laid out for us. So he's basically laid out his argument. In my opinion, he's laid it all out. It gives you the opportunity to know what he's going to say and what he's going to argue. And that's very nice of Mr. Redmond to do. He doesn't have to do that, but he's done it here today. And so I would suggest that you look into that case, and you have 2 weeks to do it with the state prosecutors to see if they can provide you with any report, a copy of the report, so that you can provide that to Mr. Redmond. In the absence of that, I would say that Mr. Weathers can communicate with Mr. Redmond, or I'm going to ask that Mr. Redmond reach out to Mr. Weathers once more. And that way, when we reconvene in 2 weeks, Mr. Redmond in good conscience can let me know that he's reached out, and then what was the outcome of that communication. I hope it's a little bit more fruitful than the last time.
Excuse me, Judge, I'm trying to catch up. If you can please repeat what report that
So anytime a criminal complaint is filed, there's a report that's made by an investigator. Those investigators then issue that report over to the district attorney's office, and then they'll open up a felony case that goes before a grand jury for indictment, or they'll just open up a complaint for a misdemeanor case. That report should list what the nature of that offense for which this defendant has pled guilty for and been placed on pretrial diversion. That report, they may not give you a copy of it, but at least if they can discuss it with you to see if it involves a Bank of America credit card, that would be helpful. And that's really what I need, because when you present your evidence, and it might be one of those cases where if they don't give it to you, you might need a lawyer to be able to ask for a court order to get it, so that you can use that court order to get that document from the district attorney's office. Again, this is one of the problems of not representing yourself and not being a licensed attorney that can request those documents from a judge. But all things considered, it may be one of those situations where it may be moot and you may be able to, through Mr. Weathers, come to an agreement with Mr. Redmond and his firm. There's a lot of still moving parts to this. And I understand that you may not totally understand every moving part, but I think the first thing that you need to do is to reach out to the criminal district attorney's office in Kentucky, where the defendant was placed on probation, pretrial diversion, and see if they'll give you a copy of the complaint. They may not. And if they do not, then you might want to consider filing or hiring an attorney to file to request a court order for that, so that it'll help you in your civil case.
Also, Judge, could I please have my counselor and the bank communicate, please?
Absolutely. I'm ordering that Mr. Redmond do so within the next 2 weeks, that he's going to reach out to him.
Yes.
Okay. All right, Mr. Redmond.
Judge, could I get that date, the date for the reset, please?
Absolutely. I'm going to give it to you right now. I'm going to give it to both of you. All right, April the 11th.
At 9:30 again, Judge?
Yes, at 9:30. April 11th,
Okay.
9:30.
Thank you very much, Judge. That's all
You're
I
welcome.
have before the court. May I be excused?
You and Ms. Alarima are both excused. Thank you.
Thank you. Y'all have a
Thank
good
you,
day.
Judge.
Your Honor, I have some depositions that have been scheduled for a couple of months, and they're about to begin in about 5 minutes. I don't see Mr. Bustos on the call. For as much as I don't want to ask for a reset, I may have to request one.
You know what? Now I have Ms. Rodriguez who's asking to be logged on. Can we get Mr. Bustos on real quick? Because I have Mr. Bustos' client. Maybe he got off to get her on. Let me, it looks like they're there. Let me get Mr. Bustos on. Can we contact Mr. Bustos?
Okay.
Good morning, Ms. Rodriguez.
Good morning.
We are trying our very best right now to get Mr. Bustos online so that we can take care of your case here as soon as possible.
Okay.
Don't hang up. In fact, just hang tight real quick.
Alrighty. Real quick. You want me to move it up here? You can tell him. Just wait right here. Okay. Oh, okay. Gotta be in front of the computer. All right. Got it. Okay. Okay.
I have Mr. Bustos logging on.
You gonna do that one? Monday? You want me to do that? Yeah, I'm just putting it.
Sir, are you available?
Yes.
Can you hear me? You're on.
Judge, can you hear me?
Yes, I can hear you. I have Miss, I believe it's Christy Rodriguez, who is logged on. Are we all ready to proceed?
We're ready to go whenever the court's ready, Judge.
All right. Who will be testifying, Mr. Bustos?
My client, Jamie Rodriguez, Judge. She's right there.
Jamie,
her mother will be testifying for her.
Big Jamie is Oralia.
Okay, Ms. Oralia Rodriguez, can I have you raise your right hand, please? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, and who will be taking the lead with Ms. Rodriguez asking questions?
Ms. Gonzalez. Well, okay, either way.
Well, no, we can let Ms. Gonzalez. That's fine, Judge. That's not a problem with me.
All right, go ahead.
We're still in the smalls. Hold on. I was multitasking over here.
Well, Judge, if she's multitasking, I can go ahead and take the lead, Judge.
Sorry, that's
All
okay.
right,
I shouldn't have my screen up because I'm doing another Zoom, but go ahead.
Okay.
Go ahead, Mr. Bustos.
Good morning, Mr. Rodriguez. How you doing today?
Good morning, doing good.
Doing good. So, Mr. Rodriguez, you know I represented your daughter, correct?
Yes,
And they were involved in an accident.
yes,
Her, I believe your other daughter, correct?
right,
Okay. And you know that we were able to come out to a favorable settlement on behalf of your daughter.
right,
In that settlement, we were able to settle for $17,500. Is that correct?
yes,
Out of that settlement disbursement, we're supposed to pay certain medical providers, office fees, attorney fees, and all those charges, correct?
you're right,
And you knew that at the time of settlement, that was, we could go to trial, we could possibly get more, or we could get less. Is that correct?
right,
Right? And at the
right,
time of settlement, we felt that the amount that she was given was a substantial amount and a satisfactory amount, correct?
right,
Okay. And we understand that out of the settlement, she's received a net due decline of $6,511.25.
okay,
Yes. Okay. And you understand that as of today, she's no longer going to be able to go back to any medical provider or go back to any hospital, any doctor in regards to this accident. Is that correct?
I understand, yes, correct.
Okay. And will you let the court know that is it correct that this accident happened in Hidalgo County, Texas?
Yes,
Here in
it did
Hidalgo,
happen,
Texas?
yes, sir.
Okay. And you're satisfied with our services from the office, the law office, Inspector Bustos?
Yes, sir,
All right. And for the court's record, Judge, in lieu of a good item and excellent defense counsel, Judge, we went ahead and reduced our fees to 33 1/3, Judge. That way we could have let the clients have more, Judge. And at this point, I'll pass the witness.
All right, Ms. Martinez, do you have any questions?
Just one question. Ms. Rodriguez, you understand that this is all the money that you're going to receive as a result of this accident?
yes, ma'am, I do,
Okay, that you understand that you can't come after my client Jennifer Alemán anymore after today?
of course.
Okay, thank you, ma'am. No questions, pass the witness.
All right, Ms. Gonzalez.
Yes, Judge, briefly. Ms. Rodriguez, you and I met along with your two daughters via Zoom. Is that correct?
Yes, sir, yes, ma'am, I'm sorry.
That's okay. That's okay. And we discussed you had some concerns about the attorney's fees and some of the expenses, correct?
Yes,
And thankfully, Mr. Bustos agreed to go ahead and reduce that so that your daughter was going to get a higher amount than originally.
I appreciate that,
Correct?
yes,
Okay. And do you believe that the new amount of $6,511.25 is in her best interest?
yes, I do,
Okay. And we also discussed that she has some additional special needs, correct? I believe she has Down syndrome.
yes, ma'am,
Okay. And you are her permanent guardian, correct? You're in charge
Yeah.
of her?
yes, I am,
Okay. And Ms. Rodriguez, you also cover all of her financial needs, her personal expenses, things like that, correct?
oh, definitely, yeah,
Okay. And because of that, we're asking, instead of this money going into the registry, since she is over 18, that be paid out directly to the client, correct?
yes,
And that's money that you would use for her benefit, correct?
definitely, yes, ma'am,
All right. And okay, and so we're asking the court, instead of putting the money into the registry of the court, given her age and her needs, that be paid out immediately, correct?
yes,
Okay. And again, you believe that's in her best interest?
oh, definitely, ma'am, yes.
Good deal. Okay, judges, those are all the questions that I have. Well, actually, just one more. Ms. Rodriguez, are you satisfied with the advice and services that I provided as the ad litem for your daughter?
Oh, yes, ma'am.
Thank you, ma'am. Okay, pass the witness, Judge.
All right, Ms.
Your Honor, may I ask? Yes, Your Honor. We've only received documentation to establish that Ms. Rodriguez has a power of attorney of her medical care of the incapacitated individual. If she is a guardian, we need the documentation that she is the guardian, our guardianship paper, so that we can issue the check directly to her. That's the only the complication that we find before us. So if we have the documentation, we just need a copy of it.
We submitted everything, ma'am, the power of attorney, everything, guardian, everything.
No, Ms. Rodriguez, what she's asking for is a legal order from a probate court that says that you're the legal guardian of Mrs. Rodriguez.
And I think what she has, Judge, if I remember correctly in our discussions, is she's got a medical power of attorney and a legal power of attorney.
Yes.
I don't think she's got a true,
I don't think there's a guardianship order from the actual court.
Your Honor, we don't have a statutory power of attorney. They only have a medical power of attorney. That's the only documentation I've received. But that was established last year. What has been discussed with me is that the incapacitated individual has moments of lucidity, and so she was able to sign for those documentation. So she could possibly still sign for it, and in which case
she can still put it in.
Ms. Rodriguez can receive it. But as it stands right now, we're kind of in a conundrum as to where to issue the check.
That's fine. They can issue it to her name. You can issue it to her name. She has her checking account. She has her checking account.
okay, just one at a time because the reporter's got to take it down. But what I was going to say, Judge, is she certainly understands what's going on. She was able to explain to me very efficiently what the accident, where it took place, how it happened. She was able to provide me with her age, her date of birth, and if in fact it is based on the representations of her mother that she has a bank account, I don't have an issue with that as her guardian, Judge. The family is very tight knit, and they certainly take care of one another. I don't have any issues that they would misuse these funds.
Judge, I also think, Judge, if the money is put in the registry of the court to help the family out, we can file our motion to remove the money from the registry of the court on the court's consideration, Judge, given the needs and what it takes in order for her to be taken care of.
So I was going to suggest, and again, I think Mr. Bustos, you spoke about it. I was going to suggest if it helps Ms. Martinez and the firm, in the issuance of the check, we can issue the check to the registry of the court, and then Ms. Gonzalez, if you would be so kind as the ad litem to deposit it in there, then Mr. Bustos can always request it from the court, and then at that point, I'm now granting it to be withdrawn from the registry of the court and then given to whomever. I can give it to, mother, guardian, daughter herself, but that kind of protects the firm from Ms. Martinez's perspective, I think. But
I agree with you, Judge. I think all corners will be taken care of then.
Yeah, I just, it's just one extra step that Mr. Bustos, you'd have to, I guess, at that point, request it from the court and have a short hearing on it.
We have no problem with that, Judge.
Okay.
Your Honor, before we haven't discussed Ms. Gonzalez's ad litem fee, so we just need to jot that down and that information before we go on.
And I don't mind putting both of you all into a breakout room right now, Ms. Martinez, Ms. Gonzalez, to see if an agreement can get reached relatively quickly on that issue.
Yes.
Let me do that real quick.
Okay, thank you.
As far as the settlement, the court's going to go ahead and approve the settlement, and based on the representation of Ms. Gonzalez, I'll approve the final judgment. As soon as it gets submitted into for my signature, then the monies will be tendered over to Ms. Gonzalez. Ms. Gonzalez will then put it into the registry of the court. Mr. Bustos will then request it from the court to be tendered over to whatever party he suggests.
Okay.
Thank you, Mr. Rodriguez. We'll go and take care of that for you, ma'am.
Okay.
Thank you, Mr. Bustos. I appreciate you.
Thank you. Thank you, Ms. Gonzalez.
Ms. Rodriguez and Mr. Bustos, both of y'all are
Thank you, Mr. Bustos. Thank you, Your Honor.
Ms. Gonzalez and Ms. Martinez, a room has been opened for you all to join so that you can see if fees can be agreed to.
Yes, sir.
Okay. Yeah. Okay.
All right, that puts me back to, I have a Cristina de la Rosa who's here. Synchrony Bank and Cristina de la Rosa, CL 200890H. This is a status conference hearing. A motion for default judgment was held. Was this a case, Ms. de la Rosa, that you were going to be in negotiation with some representative from Synchrony Bank?
Good morning, Your Honor. Actually, on my last date, I was on, but I wasn't able to get unmuted.
Okay.
So I wasn't, and I called your office immediately because I heard my name and I thought I was going to be called and I wasn't. So I went ahead and I called the credit card company and I've already made arrangements for a payment agreement.
Okay. So I just want to close it out on my end. I want to make sure that they also close it out so that you don't have this pending.
Okay.
I think it's probably best that we set it up for. So you have reached an agreement in principle.
Yes, sir. Yes, Your Honor. I have a confirmation number also.
Perfect.
And
What
they
I'm gonna-
told me that they would be sending some paperwork over
Okay.
to let, I guess, the court know.
So let me do this. They haven't done that. I'm going to try to get their attention by setting it up for what's called a DWAP, a dismissal for want of prosecution. That'll get their attention to log on and give you what you need and get it over to us as soon as possible. And in the absence of that, the case is going to get dismissed on my end. So that'll get their attention to make sure that everything gets taken care of. That's really my only way of trying to get their attention. So we're going to set this up for a DWAP. Be aware of this date that I'm about to give you. April the 20th. All right. If you don't hear from them to give you some documents to sign, please log on April 20th at 9:30. It'll be set for DWAP at that point. Okay. I'm more than certain they'll show up and then we can get their attention and see what we could do about getting the paperwork taken care of.
Your Honor, so then should I expect like an email from them so I can sign something over? And if I
Yes.
don't,
If
so
you
if I don't, then I log on.
Absolutely. That's exactly right.
Okay. All righty.
And we have your
Thank you.
information. We'll send it to you before the 20th of April if need be.
Okay. Thank you, Your Honor.
You're welcome. Thank you.
Uh-huh.
All right, with the exception of waiting for Savannah and Ms. Martinez to see if an agreement can be reached with attorney's fees, that takes care of our